When you hear the word trust, your mind might jump to, I don't know, grand old estates or maybe the super rich managing fortunes.
Hmm.
But actually, trust law, it has this surprisingly wide reach in modern life. It touches everything from asset management to future planning, often in ways you might not even expect.
That's absolutely right. And for this deep dive, we're going to really get to the heart of trust law based on the materials you've shared. Think of it as pulling out the essential bits, giving a clear, sort of engaging grasp of how trusts work today.
Exactly. Our mission here is to cut through the complexity. We want everyone listening to walk away with a really solid understanding of, how trusts are created, the different kinds, the responsibilities involved, and your materials, they're incredibly comprehensive, covering everything from history right up to the nitty-gritty of trustee duties, even what happens when things go wrong. So, ready to dive in.
Absolutely.
Yeah.
Okay, let's start with the basics, the foundations. Trust law has this long, fascinating history, right? Its roots go way back to medieval England.
Oh, really?
Yeah, it mostly came about from practical needs, especially managing land when owners were away, maybe off on the Crusades or something. So it wasn't initially just about huge wealth.
Huh. Not just sprawling estates, then, from the get-go.
Not in the very beginning, no. Over the centuries, it's evolved quite significantly,
Yeah.
shaped by both common law, court decisions over time, and statutes passed by Parliament.
Right.
Key moments. Well, the Statute of Uses in 1535 tried to simplify land ownership, and then much later, the Trustee Acts, 1925 and 2000, they really modernized things, especially around trustee powers and responsibilities. It's quite somewhat how old it is, but still adapts.
It really is. So where does it fit in today's world?
Oh, it's incredibly important now. Asset management.
Ah.
From one, helping people and organizations manage wealth effectively. Estate planning, too, obviously, giving a framework for controlling how assets are passed on.
And it's not just about tax, right? It's more about control.
Exactly. Often it's about control,
Right.
making sure specific wishes are followed, maybe more precisely than just leaving things outright. And then there are the commercial uses. Think pension schemes, investment funds, charities. Loads of them use trust structures.
Wow. Okay.
And society changes. So trust law keeps adapting. We're seeing it grapple with, new kinds of beneficiary relationships, even digital assets now.
So for anyone wanting to get up to speed quickly but properly, understanding these core ideas in the history, that really sets the stage, doesn't it?
Precisely. It's the bedrock. Okay, so now we know why they're important. How do they actually, come into being? And that leads us straight to the three certainties.
Ah, yes, the magic number 3. Tell us more.
Okay, so these three certainties, intention, subject matter, and objects, they come from a really key case, Knight v. Knight. They're like the essential ingredients. You need all three for a valid express trust. Miss one and the whole thing likely fails.
Right, okay. Let's break them down. Certainty of intention first. What's that about?
This means the person setting it up, the settler, must clearly intend to create a binding obligation on the trustee, an actual duty to hold the property for someone else's benefit.
And how do you show that intention? Does that have to be written down?
It can be in words, written or spoken, sure, but interestingly, it can also be implied by actions. There's a good case for this. Re Cayford.
Oh, yeah. Remind me about that one.
Okay, so Re Cayford involved a mail order company. They were worried about financial trouble, so they opened a separate bank account, specifically called a customer trust deposit account. They put customer advance payments in there.
Ah, to protect the customer's money if they went bust.
Exactly. And the court said, look, doing that, creating that separate account with that name, that showed a clear intention to create a trust for those customers. Even if they didn't say trust in every conversation, the conduct, the actions were enough.
Actions speak louder than words, then.
Pretty much, yeah. The court looks at the overall picture.
Mm-hmm.
And if a trust fails because the intention wasn't clear, well, the property just passes as an outright gift to the person who is supposed to be the trustee.
Mm-hmm.
No binding trust obligation was actually created.
Okay, that makes sense. So intention is number 1. What's the second certainty?
Certainty of subject matter. This one's about the property itself. You have to know exactly what assets are supposed to be in the trust. If it's not clearly defined, the trust can fail. There's a classic case, Palmer v. Simmons.
What happened there?
Well, the settler left the bulk of my estate to someone. The court basically said, what's the bulk? It's too vague, too uncertain.
Right, not specific enough.
Exactly. So the trust was void for uncertainty of subject matter, and the property just went back into the settler's general estate.
So you really need precision there. No wiggle room.
Generally, yes. Though there are nuances.
Wow.
Like if you say 50% of my shares in a specific company, That's usually okay because shares are often identical, interchangeable, intangible assets. But with tangible things, like, say, wine bottles, if you try to create a trust over 12 bottles of my wine, but you have a whole cellar full and haven't marked which 12, that probably fails unless they're clearly segregated.
Ah, like that London Wine Co. case with the undelivered wine.
Precisely that one. London Wine Co.
Yep.
Customers paid for wine, it was stored, but never separated out for each specific customer. Company went bust. Court said, sorry, no certainty of subject matter, you're just unsecured creditors. Ouch.
That really drives home the need for clear identification, doesn't it?
It really does. Oh, and one more point on subject matter.
Yeah.
The property has to actually exist when the trust is created. You can't put, like, future inheritances you hope to get into a trust right now.
Okay, got it. So clear intention, clearly defined property. What's the third one?
Certainty of objects. This is all about the beneficiaries, the people who are meant to benefit.
Oh.
They need to be clearly identified or at least ascertainable. And the level of certainty needed here actually depends on the type of trust.
Right. I remember reading there were different tests for fixed trusts versus discretionary trusts. Can you unpack that?
Sure. So for a fixed trust where the settlor decides exactly who gets what and how much, the test is strict. It's called a complete list test.
Complete list.
Meaning the trustees must, theoretically at least, be able to draw up a full list of every single beneficiary. So the description needs to be conceptually clear, we need to understand the definition of the group, and it needs to be evidentially possible to prove who fits that description.
So if I set up a trust for all my former university classmates, maybe the concept is clear, but if I lost touch and have no records, that could fail the evidential part.
Exactly. Or even something seemingly simple like the school's complete 1998 football team. If the school lost the records, you can't make the list, so the trust could be void for evidential uncertainty.
Got it. Okay, so that's fixed trusts. What about discretionary trusts? They're more flexible, right?
Yeah, they are. With discretionary trusts, the trustees have the power to choose who benefits from a defined class and how much they get. For these, the test is less strict. It's called the is or is not test from the big case McPhail v. Dalton.
The is or is not test.
Yeah, the question is basically, can you say with certainty for any person who might turn up, whether they are or are not a member of the beneficiary class, if you can definitively say yes or no for anyone, the trust is probably okay on certainty of objects.
So in McPhail v. Dalton, the class was something like officers, employees, ex-employees, and their relatives or dependents. And the court said that worked.
Yes, the House of Lords said that class description was conceptually certain. Even if finding every relative might be hard work, you could generally tell if someone was a relative or dependent, or wasn't. A later case, Rabadan, No. 2, confirmed terms like relatives and dependents are okay conceptually. And importantly, it also said that just having some evidential difficulties, maybe struggling to prove if one specific person is a relative, won't necessarily kill a discretionary trust.
Ah, okay. That's a really key difference then. Evidential uncertainty can sink a fixed trust's complete list, but maybe not a discretionary trust's is or is not test.
Precisely. But there are still limits for discretionary trust. A trust can be void if the class is just so huge that it's administratively unworkable. Like if you said, for the benefit of all the inhabitants of Greater London, how could trustees even begin to survey that group?
Right, impossible.
And there's also this idea of capriciousness. If the settler's intention seems completely random or senseless, theoretically that could void it too, though it's apparently never actually happened in a reported case.
Okay, so the three certainties, intention, subject matter, objects, absolute bedrock. Miss one and it likely crumbles.
Exactly. So assuming we have those three certainties sorted, let's look at the different shapes these trusts can take.
Okay. We've mentioned fixed and discretionary already. Can we dig a bit deeper into how they actually differ in practice?
Definitely. So just to recap, fixed trusts, beneficiaries and their shares are set in stone by the trust document, the trustee. No discretion at all about who gets what or when. Their job is just to follow the instructions.
Like, pay the income equally to my 3 kids.
Exactly that. Clear instructions, fixed shares. And because it's all defined, the beneficiaries know exactly what they're entitled to and can legally enforce those rights against the trustee if needed.
Makes sense. Very predictable. And discretionary trusts again.
Much more flexible.
Mm-hmm.
Trustees have the power, the discretion to choose from a defined group, say, my nieces and nephews, who gets something, how much they get, and when they get it.
So going back to that McPhail v. Dalton example, the trustees for the employees and relatives could decide, okay, this year employee A gets a bit more, relative B gets something, ex-employee C gets nothing.
Precisely. But, and this is crucial, that discretion isn't totally free rein. Trustees of discretionary trusts still have serious duties. They have to actually consider periodically whether and how to use their power. They must avoid conflicts of interest, think about suitable investments, act impartially between potential beneficiaries.
So it sounds like managing a discretionary trust needs a lot more active judgment from the trustees.
It certainly does. And while that flexibility can be really useful, it can sometimes lead to, well, disputes if beneficiaries feel the trustees aren't being fair with their decisions.
Any other main types we should know about?
Yes, one other really key one is the bare trust. This is the simplest form. You have a beneficiary who's an adult, fully capable, and absolutely entitled to the trust property.
So what does the trustee do?
Basically, the trustee just holds the legal title. They have to follow the beneficiary's instructions. The beneficiary has full control. It's almost like the trustee is just a nominee holding it on their behalf.
Okay, like a placeholder.
Pretty much. Right, so we've got the types. Now, what else do you need besides the three certainties to actually get a trust properly set up and working? That brings us to formalities and constitution.
Formalities and constitution sounds a bit legalistic, like setting up a company.
There are some parallels, yeah. Besides the three certainties, some trusts, especially express trusts made during someone's lifetime, inter vivos trusts, need to follow specific formalities. These are different from trusts and wills, which have their own rules under the Wills Act.
What kind of formalities for lifetime trusts? Writing.
Often, yes, especially if it involves land. Section 51B of the Law of Property Act 1925 usually requires trusts of land to be evidenced in writing. But beyond the initial paperwork, there's the vital step of constitution.
Constitution meaning?
Getting the actual legal title of the trust property transferred from the settlor to the trustees. Until that happens, the trust isn't properly constituted. The trustees don't legally own the property yet, so they can't really manage it.
And what if the settlor promises to set up a trust, has the intentions subject objects, but just never gets around to transferring the property?
Well, this often bumps up against that old equitable maxim. Equity will not assist a volunteer.
A volunteer being someone who hasn't paid anything.
Exactly. Someone who hasn't given consideration. Generally, if a settlor promises a trust but doesn't complete the property transfer, the intended beneficiaries, being volunteers, usually can't go to court and force the settlor to finish the job. Equity won't step in to perfect an imperfect gift or trust.
But I feel like I read about exceptions to that. Equity sometimes helps.
You're right, there are exceptions. A big one is proprietary estoppel. This can sometimes help where someone was given an assurance they get an interest in property, they relied on that promise to their detriment, and it would just be fundamentally unconscionable for the person making the promise or their estate to go back on it.
Can you give an example?
Okay, imagine a farmer tells his daughter, who works on the farm for years for low wages, one day, all this will be yours. She relies on that, maybe turns down other jobs. If he then leaves the farm to someone else in his will, she might have a claim based on proprietary estoppel.
Because of the assurance, her reliance, the detriment she suffered.
And the unconscionability of denying her claim. Those are the key elements.
Yeah.
Assurance, reliance, detriment, unconscionability. It's about preventing unfairness when strict legal rules might allow it.
Right, that makes sense. Okay, another thing related to setting up trusts. The rule against perpetuity. That sounds quite old-fashioned.
It is old, but still relevant. It basically stops settlers from locking up property and trusts forever, or for, ridiculously long periods, generations into the future.
So trusts can't last indefinitely. There's a time limit.
Yes. For most trusts created after April 6th, 2010, there's now a statutory perpetuity period of 125 years. The beneficial interests that become definite within that time.
125 years. That's still quite a long time.
It is, but it sets a limit. For some specific types, like non-charitable purpose trusts, the rules can be stricter, often limited to maybe 21 years, unless the trustees can spend all the capital before then. The whole point is to stop property being tied up and becoming unusable for generations.
Okay, so trusts have a shelf life, more or less. Now, once a trust is set up and running, let's talk about the beneficiaries. What exactly are they entitled to?
Good question. This gets into beneficial entitlement. First, it's useful to distinguish between capital, the actual trust assets, the pot of money or property and income, which is the return generated by that capital, like rent or dividends. A settlor can decide if a beneficiary gets income, capital, or both.
And the type of interest a beneficiary has can differ too, right?
Absolutely, you can have a vested interest. That means the beneficiary's entitlement isn't conditional on anything happening, it's theirs.
Okay.
Now, a vested interest can be vested in possession, meaning they get the benefit right now, or vested in remainder, meaning they have a definite right to get it in the future after some other interest ends.
So, like, if a trust says income to my wife for her life, then capital to my son, the wife has a vested interest in possession, the income, and the son has a vested interest in remainder, the capital, but later.
Exactly that. Perfect example. Then, contrasting with vested interests, you have contingent interests.
Contingent meaning conditional.
Precisely. The beneficiary's entitlement depends on some future event happening or a condition being met, like to my nephew if he reaches age 25. Until he hits 25, his interest is contingent. It's uncertain if he'll ever get it.
Okay, vested versus contingent. What about fixed versus discretionary interest? We touched on that with the trust types.
Right, so a fixed interest ties back to fixed trusts. The beneficiary is entitled to a specific defined share or asset, no trustee discretion involved. A discretionary interest, conversely, is what potential beneficiaries have under a discretionary trust. They have a hope, an expectation maybe, but no enforceable right to anything specific until the trustees actually exercise their discretion in that person's favor.
Got it. And you also mentioned successive interests.
Yes, that's just where different beneficiaries are set up to benefit from the same trust property one after the other in sequence, like our wife for life then son example. That's a successive interest structure.
Okay, like a relay race of benefits passing along. Now, there's this really interesting rule. I came across the rule in Saunders v. Vautier. It sounds like it gives beneficiaries a surprising amount of power.
It really does. The rule in Saunders v. Vautier is a fundamental principle, and yeah, it emphasizes beneficiary autonomy.
Yeah.
It comes from an 1841 case. Essentially, it says, if you have a beneficiary, or all the beneficiaries together, who is an adult of sound mind, the legal term is sui juris, and they are absolutely entitled to the entire beneficial interest.
Okay.
They can collectively tell the trustees, hand over the legal title, we're ending the trust, even if that goes completely against what the original settlor wanted.
Wow. They can override the settler's wishes. Can you remind us of the original case?
Sure. In Saunders v. Vautier, a trust was set up to hold shares for his son until he turned 25, with the income accumulating until then. But when the son reached 21, the age of majority back then, he said, right, I'm an adult, I'm the only one entitled, give me the shares and the accumulated income now.
And the court agreed, even though the trust said wait till 25.
Yes, the court upheld his right. The thinking is, if the beneficiaries are legally competent and between them own the entire beneficial interest, why shouldn't they be able to decide what to do with their own property?
So it applies to groups too, if there are multiple beneficiaries.
Yes, it's been extended. If all the beneficiaries meet the criteria, all adult, all mentally capable, and together they hold the absolute interest and they all agree, they can collapse the trust. It could even apply to discretionary trusts if you can get all the potential objects together and they all agree.
That's quite something. But surely there are limits. It can't apply all the time.
Oh, absolutely, there are strict limits. Every beneficiary must be sui juris, adult and capable. They must all be absolutely entitled, with no conditions or possibilities of others becoming entitled later. And crucially, they must all unanimously agree. If even one beneficiary says no or is minor or lacks capacity, the rule can't be used.
Okay, so powerful, but only in specific circumstances. Right. Let's switch gears slightly. What about trusts set up not for people, but for purposes, like charities or maybe other goals? I know there's a big split here.
Yes, a very important distinction between charitable purpose trusts and non-charitable purpose trusts. Most trusts benefit people, but sometimes a settlor wants to achieve an objective.
Let's start with the non-charitable ones. What are the issues there? They seem tricky.
They are tricky. The main problem is the beneficiary principle. The general rule in trust law is every trust needs a beneficiary who can go to court and enforce it, hold the trustees accountable.
And a purpose can't sue, right?
Exactly. So a trust just for a purpose generally fails because there's no one to enforce it. The classic case is Ray Astor. A trust was set up for vague purposes like preserving the independence of newspapers. The court said, nope, void no beneficiaries to enforce it. Seems quite strict, doesn't it? Especially when people want to set up funds for, say, environmental projects that don't directly benefit specific people.
So just having a goal isn't usually enough. Are there any exceptions for non-charitable purposes?
There are a few. One important category comes from the case Reed Enley. This said that if a trust looks like it's for a purpose, but that purpose actually provides a direct, tangible benefit to identifiable individuals, it might be valid.
How did that work in Red Denley?
That case involved land held on trust to be used as a sports ground, primarily for the employees of a specific company. The court said, well, the employees get a clear benefit here, they're identifiable, so they effectively have standing to enforce the trust. It's different from Reaster, where the benefit was much more nebulous.
Okay, so if people benefit indirectly but clearly from the purpose, and what about those weird ones I read about? Trusts for pets or graves.
Ah, yes, the anomalous exceptions. These are historical quirks, sort of concessions to human weakness, the courts have said. They include trusts for the care of specific animals, Russendine, trusts for building or maintaining graves and monuments, Musset v. Bingle, re Endicott, and sometimes for saying private masses. But, and this is key, these are seen as historical anomalies. The courts are very reluctant to create any new exceptions like these.
So don't try setting up a trust for your pet parrot's political campaign.
Probably not a winner, no. And remember, the rule against perpetuity, it usually applies quite strictly to these non-charitable purpose trusts. Because there are no beneficiaries to use the Saunders v. Vautier rule to end it early, they generally have to be limited in time, often to 21 years, unless the capital can be spent out sooner. The 125-year rule doesn't typically apply here, although the wait-and-see approach might save some that could last too long but don't in practice.
Okay, that covers the tricky non-charitable ones. What makes charitable trusts different and, well, generally valid?
Charitable trusts are also purpose trusts, but they get special treatment because they're seen as benefiting the public. They have huge advantages. They are exempt from the beneficiary principle. The Attorney General or Charity Commission enforces them on behalf of the public. They're exempt from the rule against perpetuity, so they can last forever. And they usually get significant tax breaks.
Okay, sounds good. But what actually counts as charitable?
Well, the definition has evolved, but now it's mainly governed by the Charities Act 2011. It lists recognized charitable purposes. These include things like the relief of poverty, the advancement of education.
Like museums or research?
Exactly. Museums, research, sometimes even promoting sport in schools, Mariette. Also, the advancement of religion, and then this broad category of other purposes beneficial to the community.
That sounds quite wide. What fits in there?
It stems from an old 1601 statute preamble. Courts have included things like promoting health, community development, animal welfare, environmental protection. Even providing inexpensive sanitary disposal of the dead, Scottish burial reform, or access to free internet have been considered. It's pretty diverse.
But just having one of those purposes isn't automatically enough, is it? There's something about public benefit.
Crucial point. Yes, every charitable trust must demonstrate public benefit. This has two parts. First, the purpose must benefit the public in general, or a sufficient section of the public. It can't be limited to a private group linked by, say, employment at the same company that was the issue in Oppenheim v. Tobacco Securities. There can't be a personal nexus.
Okay, no private clubs disguised as charities. What's the second part?
The benefit itself must be identifiable, tangible, and generally must outweigh any potential harm or detriment associated with the purpose. Like in the National Anti-Vivisection Society case, the court decided the alleged benefit of banning animal testing was outweighed by the potential detriment to medical science. Also, generally, trusts with purely political aims aren't charitable.
Right. And if a charity's original purpose becomes impossible later on, say a trust to find a cure for a disease that then gets cured.
That's where the Cypres doctrine comes in, pronounced Cypre. If the original purpose fails or becomes impractical, the Charity Commission or the court can apply the funds to another charitable purpose that's as close as possible, Cypre, to the original one. It stops the money getting stuck.
That makes sense. Keeps the charitable funds working. Okay, shifting again. What about trusts that aren't explicitly declared but kind of arise from the situation, like resulting trusts?
Exactly. Resulting trusts are implied by law. They happen when property is transferred, but the beneficial interest effectively bounces back, or results, to the person who made the transfer. There are two main types, automatic and presumed.
Okay, automatic first.
An automatic resulting trust happens when an attempt to create an express trust fails somehow. Maybe the beneficiaries weren't clearly defined, or the purpose failed. If the beneficial interest hasn't been fully given away, it automatically results back to the settlor. The intended trustee holds it on trust for the original owner.
So it's like a safety net if the express trust doesn't work out?
Kind of, yeah. It prevents the property being ownerless in equity. The other type is the presumed resulting trust.
Presumed, meaning the law assumes it.
Yes, in certain situations. The classic one is where someone contributes money to buy property, but the legal title is put in someone else's name. If there's no evidence it was meant as a gift, the law presumes the contributor didn't intend to give away their beneficial interest. So the legal owner is presumed to hold the property on resulting trust for the contributor, usually in proportion to their contribution.
So if I chip in 20K for a friend's 100-pound K flat purchase, and it's only in their name, the law might presume I have a 20% beneficial share via a resulting trust.
That's the basic starting point, yes. However, there's a counter-presumption called the presumption of advancement.
Advancement, meaning it was a gift.
Historically, yes. In certain relationships, typically father to child or husband to wife, the law presumed the transfer was intended as a gift or advancement. But this presumption is much weaker now, especially the husband to wife part, reflecting societal changes. And crucially, in the context of cohabiting couples buying homes, the courts, particularly in cases like Stack v. Dowden and Jones v. Kernot, have really moved away from relying on simple resulting trusts based just on unequal contributions.
Ah, so for couples and family homes, it's more complicated.
Much more complicated. The courts now look much more at the whole relationship, the parties' shared intentions, their entire course of conduct, to figure out beneficial ownership, often using common intention constructive trusts instead.
Right. That brings us neatly to trusts of the family home, especially for unmarried couples splitting up. That must be a common issue.
Incredibly common and often legally complex. When unmarried couples separate and they haven't got a formal declaration saying who owns what share of the home, the courts often turn to common intention constructive trusts, CICT, or sometimes proprietary estoppel, which we mentioned earlier.
And the legal title might be in one name or both.
Exactly. If it's in both names, they might be joint tenants, equal shares, automatic inheritance by survivor, or tenants in common, distinct shares, passed via will. But even if the house is legally in only one partner's name, the other partner might still argue they have a beneficial interest through a CICT.
Okay, so how does a common intention constructive trust actually arise?
It requires two main things. First, evidence of a common intention between the partners that they would both have a beneficial interest in the property. Second, the partner claiming the interest must have acted to their detriment in reliance on that common intention.
How do you show the common intention? Does it have to be written?
It can be expressed, meaning they actually discussed it and agreed, we'll share this 50-50 or whatever. Though, as we said, for land, proving an express trust usually needs writing under S531B of the Law of Property Act. But the common intention can also be inferred from conduct.
Inferred, like from paying bills.
More significantly, from direct contributions to the purchase price, paying the deposit, making mortgage payments. The courts might infer, why would they pay the mortgage unless they intended to have a share? Indirect contributions or paying household bills are less likely on their own to be enough to infer intention, though they might be relevant later when quantifying the share.
Okay, so you need that shared intention, express or inferred, and then the detrimental reliance.
Yes, that's crucial too. The person claiming the share must show they acted to their detriment, relying on that shared intention. This could be making those financial contributions, but maybe also doing significant renovation work, or even giving up a career based on the understanding they had a stake in the home.
And proprietary estoppel could also be relevant here too.
Yes, sometimes the facts might support a claim under proprietary estoppel, as well as assurance, reliance, detriment, unconscionability. Both CICT and estoppel are tools equity uses to achieve fairness in these often informal domestic situations.
Right, trying to reflect the reality of the relationship. Okay, now, what about people outside the trust? Can strangers get dragged into liability if something goes wrong?
Yes, absolutely. If a trustee breaches the trust, causes a loss, and maybe the trustee has no money themselves, the beneficiaries might look to see if any third parties, any strangers to the trust, can be held liable. Equity can sometimes impose liability on them.
How? What kind of liability?
There are three main ways a stranger might become liable: recipient liability, accessory liability, and intermeddling.
Okay, let's take those one by one. Recipient liability, is that just receiving trust property?
It's receiving trust property, knowing it's being transferred in breach of trust, or learning about the breach later and then dealing with the property in a way that's inconsistent with the trust. It's often called knowing receipt. The level of knowledge required can be complex, but essentially you receive property you shouldn't have, with some level of awareness.
Okay, so it's about receiving the property wrongly. What about accessory liability?
This is different. It's not about receiving the property. It's about helping the trustee commit the breach. It's often called dishonest assistance.
Dishonest assistance. So the stranger has to be dishonest.
Yes, that's the key element. The stranger must have dishonestly assisted the trustee's breach. If they did, they can be held personally liable to compensate the trust for the loss, even if they never actually touched the trust property themselves. It's about their state of mind and their actions in facilitating the wrongdoing.
Got it. Helping the trustee be bad. And the third one, intermeddling.
Intermeddling is basically acting like a trustee without actually being appointed. Someone takes it upon themselves to deal with trust property, make decisions, exercise powers they don't have. If they mess up and cause loss, they can be held liable just as if they were a proper trustee. They're a trustee de son tort, a trustee of their own wrong.
Okay, so stepping into the role without permission. Right, we've talked a lot about setting up trusts and beneficiaries. Let's focus back on the trustees themselves. We know they have a duty of care, but what other major duties do they owe? Fiduciary duties.
Absolutely. Trustees have a raft of duties. Some are fiduciary, some non-fiduciary. A core fiduciary duty is the duty not to profit from their position. They can't make personal gains from being a trustee unless the trust deed specifically allows it, or the court approves, or all the beneficiaries consent.
Like that case you mentioned, Williams v. Barton, where the trustee got a commission.
Exactly. He recommended a stockbroker who then paid him half their commission. Court said that commission belonged to the trust. This duty also generally means trustees can't charge for their time and trouble.
Oh, really? They work for free?
Traditionally, yes, unless they were a professional trustee, and the trust document included a charging clause. The Trustee Act 2000 now allows reasonable pay for professional trustees, in some cases even without a clause. But having an express clause is still standard practice.
Okay, so no secret profits. What's another big one?
The duty not to purchase trust property. This is the self-stealing rule mentioned in Tito v. Waddell. Note 2. A trustee cannot buy property from the trust for themselves. Such a sale can be automatically overturned by the beneficiaries, even if the price paid was fair.
Even if it was a totally fair price. Wow, that's strict.
Very strict. The only exceptions are if the trust deed allows it, a court order permits it, or all the adult-capable beneficiaries unanimously agree to the sale. It's about avoiding any possibility of conflict.
Makes sense. Prevents temptation. Any others?
Yes, related to that is the broader duty not to put themselves in a position where their personal interest and their duty to the trust conflict. That came up in Regal Hastings. Equity really frowns on any situation where a trustee's loyalty might be divided. Other duties include acting in good faith, maintaining confidentiality. It's a demanding role.
Definitely sounds like it. Breaches happen when their actions conflict with the beneficiary's interests, maybe benefiting themselves or someone else, or just failing to disclose conflicts. So who can actually be a trustee, and how do they get appointed in the first place?
Well, the settlor usually picks the first trustees when they create the trust, either in the deed or their will. They can even appoint themselves. Later on, if a trustee needs replacing, maybe they die or retire, the power to appoint a new one is usually given by the trust document itself, often to the remaining trustees.
And if the document doesn't say, or there are no trustees left?
Then the personal representatives of the last surviving trustee might be able to appoint someone. Or ultimately, the court can step in and appoint trustees under the Trustee Act 1925. There's also a provision in the Trusts of Land and Appointment of Trustees Act 1996, allowing beneficiaries in some cases to direct the appointment of a new trustee if an existing one lacks capacity.
Okay. And once they're appointed, what are their immediate jobs?
First things are to find out exactly what the terms of the trust are, who the beneficiaries are, what the trust property is, and make sure the property is legally vested in their names, along with any co-trustees. They also need to look over past accounts and check if the previous trustees did anything wrong.
And ongoing duties.
Acting unanimously with co-trustees, keeping proper accounts, acting impartially between different beneficiaries or classes of beneficiaries, investing the trust property prudently, and always avoiding those conflicts of interest.
We keep coming back to that duty of care. Can you flesh that out a bit more? What standard are they held to?
Right. The statutory duty of care under the Trustee Act 2000 is key. It says trustees must exercise such care and skill as is reasonable in the circumstances. But it explicitly says you have to consider any special knowledge or experience the trustee has or claims to have.
So a professional trustee, like a lawyer or accountant, is held to a higher standard than, say, a family friend.
Exactly. The professional standard applies if they're acting in the course of a business or profession. The general standard is often described by older cases like Spate v. Gaunt or Re Whiteley as being like an ordinary prudent man of business managing their own affairs, but crucially investing for the benefit of other people. It implies a bit more caution than perhaps speculating with your own money.
Right, long-term security for others, not just personal gain. Okay, so what if they don't meet these standards? What exactly is a breach of trust?
A breach of trust is essentially any act or omission by a trustee which is contrary to their duties. As the Nestle case put it, making wrong decisions or failing to make necessary ones. It doesn't matter if the trustee meant well. Intention is usually irrelevant to whether a breach occurred. Did their action or inaction fall below the standard required, and did it cause loss or result in an unauthorized gain?
And if there are multiple trustees, who is liable?
Generally, they are jointly and severally liable. This means the beneficiaries can sue any one trustee for the entire loss, leaving it up to that trustee to try and recover contributions from the others if appropriate.
Ouch. So one trustee can end up carrying the can for everyone.
Potentially, yes. And new trustees aren't liable for past breaches before their time, but they do have a duty to investigate and pursue remedies for past breaches if they find them. Retired trustees generally remain liable for breaches committed during their tenure.
Okay, so a breach happens. What can the beneficiaries actually do? What are the remedies?
The main goal is usually to put the trust fund back in the position it would have been in if the breach hadn't occurred. Originally, equity liked ordering the trustee to restore the specific property if possible. Nowadays, it's often about monetary compensation for the loss suffered, often called equitable compensation.
Is it like damages in contract law? Do you need to prove causation?
It's similar, but not identical. The strict common law rules of causation, remoteness, foreseeability don't apply in quite the same way. But there does need to be a causal link. The loss must flow from the breach. The target holdings case is important here, showing the need for a common-sense connection between the breach and the loss.
So beneficiaries can make a personal claim against the trustee, using the trustee's own money.
Yes. If there's a breach causing loss, the beneficiaries can sue the trustees personally to make good that loss to the trust fund, usually plus interest. But trustees might have defenses.
Okay. What kind of defenses? Can they get off the hook?
Sometimes. A big one might be an exemption clause in the trust deed itself. Settlers sometimes put these in to protect trustees, especially non-professional ones. However, these clauses are interpreted strictly and generally can't excuse fraud or dishonesty.
What else?
Another defense is beneficiary consent. If all the beneficiaries were adults, mentally capable, fully informed about what was happening, and they consented to the action that caused the breach, the trustee might be protected. Also, Section 61 of the Trustee Act 1925 gives the court a power to excuse a trustee, wholly or partly, if they acted honestly and reasonably and ought fairly to be excused.
So even if they technically breached, if they acted reasonably and honestly, the court might let them off.
It's possible, yes. Then there are limitation periods, usually 6 years from the breach, but the clock might start later for beneficiaries with future interests or if there was fraud. And the equitable doctrine of latches might apply if a beneficiary waits far too long to complain, making it unfair to pursue the claim.
Okay. And you mentioned trustees being jointly liable. Can one trustee make another pay their share? Yes, that's indemnity and contribution. If one trustee pays out for a breach, they might be able to claim a contribution from their co-trustees. In some cases, like if one trustee was a solicitor who advised the others wrongly or benefited personally from the breach, they might even have to indemnify the others completely.
Right. Now, that was personal claims against the trustee. What about proprietary claims, getting the actual property back?
Yes, that's the other main avenue. Instead of just seeking money from the trustee, a proprietary claim follows the trust property itself or its traceable proceeds. If the trustee wrongly took trust money and bought, say, a painting with it, the beneficiaries might be able to claim the painting itself belongs in equity to the trust.
How does that work? You need to trace the property.
Exactly. You need equitable tracing. This requires, usually, a fiduciary relationship, like trustee-beneficiary, and the property must still be identifiable even if it's changed form or been mixed with other money. The Foskett v. McCune case is key here, showing how beneficiaries could trace trust money into life insurance proceeds. It's about attributing the value, not strict causation. If you can trace it, you might get a charge over the new asset or even claim ownership of it.
Okay, that's a powerful remedy if the property still exists in some form. This has been incredibly thorough. Just to finish off, can we quickly run through some of those specific scenarios from the source materials MCQs? just to see these principles in action.
Sure, good idea. So that paramedic scenario, sending a check saying most of it to your son, balance to daughter, that's likely void for uncertainty of subject matter most, and balance are too vague. So the money would probably be held on a resulting trust for the sender.
Right, it bounces back.
The friend's buying a house with unequal contributions but joint names. Without clear agreement, the starting point used to be a presumed resulting trust based on contributions. But now after Stack v. Dowden, it's more likely a common intention constructive trust analysis, looking at their whole conduct. Could still end up reflecting contributions, or maybe 50-50 depending on inferred intentions.
Okay. And Alice and Bob. Verbal agreement to share. Alice pays more deposit.
Classic common intention constructive trust territory. The express verbal agreement might not satisfy S.531b for land, but it's strong evidence of common intention. Her contribution is detriment. She'd likely get a beneficial share reflecting that intention or contribution.
The grandchildren wanting the trust fund early, even though the trust said wait.
That's Saunders v. Vautier. If they're all adults, capable, and together own the whole pot, they can demand it early, overriding the settler's timeline.
Sarah knowingly receiving funds transferred in breach.
Clear knowing recipient liability. She'd likely have to return the funds or their value.
Jane, the advisor, dishonestly suggesting a dodgy investment.
Sounds like dishonest assistance. Accessory liability. She could be personally liable for the loss.
Emma, the beneficiary, making unauthorized investment decisions.
That's intermeddling, acting like a trustee without authority. She could be liable for any losses caused.
Lucas, the trustee, prioritizing his own company's interests.
Breach of the fiduciary duty of loyalty, duty to avoid conflicts of interest.
Rebecca hiring her own firm without telling anyone.
Again, conflict of interest, potential breach of the self-dealing or fair dealing rules depending on specifics. Needs disclosure and consent.
Beneficiaries trying to fire a trustee just because they dislike them.
Generally, beneficiaries don't have an automatic right to remove trustees unless the trust deed gives it to them, or they can rely on statutory powers, like under Tilato 1996 for incapacity, or persuade a court there are grounds. Mere dislike usually isn't enough.
Advancing capital to someone without the life tenant's required consent.
Definite breach of the terms of the trust.
Eleanor making investment decisions.
Subject to the statutory duty of care under the Trustee Act, 2000 needs to be prudent, consider diversification, suitability, maybe get advice.
Michael making an imprudent investment causing loss.
Potential breach of the duty of care. He could be personally liable to make up the loss.
Elena's high-risk investments protected by an exemption clause.
The clause might protect her from liability for negligence, but usually not if her actions were reckless or dishonest. Exemption clauses have limits.
And Jonathan investing against the trust's green policy, causing loss.
Potential breach of duty if the policy was a binding term or reflected the beneficiary's interests. Could lead to equitable compensation claim to cover the financial loss caused by ignoring the mandate.
Wow, okay. That really brings it all together. So wrapping up, we've covered the absolute necessity of the three certainties, the key differences between fixed and discretionary trusts, that powerful rule in Saunders v. Vautier for beneficiaries, the minefield of purpose trusts, how resulting and constructive trusts fill the gaps, liability for trustees and strangers, and those fundamental duties trustees owe. It's clear, isn't it? Trust law might seem old, but it's so central to how things are structured.
Absolutely. And hopefully this deep dive gives everyone a really solid handle on those key principles from the materials you shared. It's like a shortcut to getting properly informed in this complex area.
Definitely. So thinking about all this, the flexibility, the potential for things changing, what's a final thought for us to mull over, maybe about how these old principles keep up with modern life?
That is a great question to ponder. Given that constant tension between what the settler originally wanted, the rights and needs of beneficiaries as life unfolds, and just broader changes in society, how will these core trust principles continue to adapt? Think about challenges like digital assets, cryptocurrencies, NFTs. How do you hold those on trust effectively? Or increasingly complex family setups. What might be the next big legal shifts we see to make sure this centuries-old framework stays fit for purpose? Maybe something to explore further if any particular case or idea we discussed sparked some interest.